Your divorce trial is over. The judge says the evidence is closed. You walk out of the courtroom thinking it's finally done. But then something new comes to light. Maybe you discover a hidden bank account. Maybe your spouse suddenly gets a new job or bonus. Maybe you uncover messages or financial records you didn't have before. So the question is, can you reopen the evidence in a Connecticut divorce case after trial but before the judge issues a decision? The short answer is sometimes. I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut, and today I'm going to explain how reopening evidence works in Connecticut divorce cases, what judges actually look at, and what mistakes people often make. First, let's talk about what it means when the judge closes the evidence. In a Connecticut divorce trial, once both sides finish presenting testimony and exhibits, the judge will formally close the evidence. That means no more witnesses, no more documents, no more factual information added to the record. And at that point, the case is no longer in the parties' control. The judge reviews the evidence, applies the law, and eventually issues a decision. The judge has 120 days from the close of evidence to issue that decision. And this is important because many people assume that if something important comes up, the judge has to consider it, and that's not true. Once evidence is closed, the only way to get new information before the judge is to ask for permission. So in Connecticut, the procedural mechanism is called a motion to reopen evidence. This is a formal request asking the judge to reopen the evidentiary record so that new evidence can be admitted. And here's the key point. This is discretionary. The judge does not have to allow it, even if the evidence seems important to you. You're not entitled to reopen the case just because something new came up. Now, with that said, there have been Supreme Court cases that say a judge may not arbitrarily or unreasonably reject a motion to introduce additional evidence. If failing to open the evidence creates a serious danger of a miscarriage of justice, the judge is supposed to open the evidence. So when a judge decides whether to reopen evidence, they typically focus on several core factors. Let's go through the most important ones. First, why wasn't the evidence presented earlier? This is usually the first question the judge asks. Was the evidence genuinely unknown at the time of trial, or could it have been discovered earlier with reasonable diligence? Judges are often much more receptive when the evidence truly didn't exist yet, or it was concealed and only discovered later. They are far less sympathetic when the evidence was available all along, could have been obtained with better preparation, or was simply overlooked. Next, the judge will evaluate whether the evidence is actually new. Not all new evidence is treated the same. Judges distinguish between newly discovered evidence and evidence that is cumulative, repetitive, or just strengthens a weak argument. For example, repeating the same financial claim with a slightly different document usually won't justify reopening the case. Evidence that only goes to credibility rather than substance is also less likely to succeed. Next, a judge will evaluate if the evidence materially matters. This is critical. The judge will ask, would this evidence realistically affect the outcome of the case? If the evidence wouldn't change the court's decision in a meaningful way, the judge is unlikely to reopen the record. And finally, is it fair to the other party to open the evidence? Judges consider fairness and efficiency. They'll look at questions like, would reopening evidence prejudice the other side? Would it require new discovery? Would it significantly delay the decision? Connecticut judges value finality. They don't want trials to become endless. So let me give you a few quick examples. After trial, a spouse discovers a previously undisclosed bank account with substantial funds. This is the type of evidence that would likely justify reopening the evidence, especially if the account was intentionally concealed, the funds are significant, or the evidence couldn't reasonably have been discovered earlier. Another example is after evidence closes, one spouse gets a new job with higher income. This is trickier. The courts may see this as a post-trial change, not evidence that existed during trial. The judge may decline to reopen and instead treat it as a future modification issue. And finally, let's say new text messages are found that support claims already made at trial. If they don't materially change the analysis, reopening is unlikely. Now, timing matters. Everything we've talked about applies before the judge issues a decision. Once a decision is issued, you would have to file a motion to open the judgment, not just a motion to open the evidence. The legal standards at this point become even trickier. So if something truly important comes to light, timing is critical. The bottom line is this: yes, evidence can be reopened in a Connecticut divorce case after trial but before a decision, but it is not automatic. Judges look at why the evidence wasn't presented earlier, whether it's truly new, whether it materially affects the outcome, and whether reopening the case is fair. If something new comes to light, it's important to act quickly and strategically. So as usual, if you have any additional questions, you can contact our office, and if you are looking for representation in a divorce or family law case here in Connecticut, we would invite you to contact our office as well.